the investments that were essentially made are not only lost, but like further investments that could have been made to like help countries like India have more FDI or literally have more development, literally doesn't happen because the faith upon which most of these agreements are made are broken. And there's no reason for people to believe that there's going to be proper redressal mechanisms. Secondly, I'm going to talk about why we offer a better way out of this. But before that, I'll take closing on.
Right. So your explanation for why we need this mechanism is that it's too complicated to go through the government. Why is it any less complicated to go through an arbitration process with another government?
Okay, perfect. This is where I was going with anyway. First, we think it cuts rapidly the amount of time it takes for decisions to come, to the extent you don't really have to go to for international litigation, and you have like agreed upon laws and jurisdictions the way arbitration clauses normally have. You agree that there's going to be a seat of jurisdiction, and you agree that there's going to be a particular law that applies on said seat of jurisdiction. A lot of ties which like hold you back in terms of like getting proper redressal and the alternatives I've already told you simply go away. But it's a lot more fairer because you get the scope of appointing independent arbitrators who then probably go and choose another third arbitrator who's going to do that. But comparatively, notice both parties have equal say in this matter, and nobody can claim that there's going to be any like bullying of powers or anything like that. But secondly, notice that more states are more likely to listen because of the aforementioned reasons. But thirdly, arbitration in and of itself is something that's much more universally accepted than any other form of redressal. Notice how. First, ICSID guidelines are something that most countries abide by, even a country like China, to the extent that they've not like really like taken anything. Like China, after defaulting against UK literally went and actually gave the award that the arbitration awards like that was awarded. But secondly, also like literal domestic courts within countries like India recognize that there are certain powers that arbitration bodies hold, and they are going to comparatively be like a lot better. The benefits that all the harms that we've told you about are sought. Comparatively, even if it's not the best redressal we offer, it's an addition to the existing mechanisms they can approach and do this. More on this from my DPM. For all these reasons, proud to propose. Sorry for exceeding.
All right, cool. Thank you for that, Elo.
Hello, am I audible? Right, just give me 15 seconds.
Yep.
I'll start in 3, 2, 1. The problem with opening government is that they assume that the disputes that are caused between an investor and a country is always caused by the home government, and this always happens because of an unfair change in policies of the home government, of say like randomly not allocating them land, or like randomly making it very difficult for them to do business in that country. But we think they've given no structural reason why that is true. We think it's equally likely that companies might renege on promises of investment. That is to say, they might promise they're going to invest. They might get like huge tracts of land by promising that investment, but the quantum of investment that they make would be far lower than what they've claimed. Or else they might get tax breaks promising like huge levels of unemployment, but the number of people they hire might be far lesser than the one they promised, right? Which means the first question in this debate is which is more likely, right? But is it more likely that governments will renege on their promises, or is it more? Three reasons actually why we think it's likely to be companies, right? Firstly, notice there is a mismatch of power here, right? Companies that invest always have higher degrees of capital and always almost exclusively are born from home countries which are more developed than the country they're investing in, right? This is extremely important because countries often seek to back their corporations, because these corporations are an important source of tax revenue and employment for those countries. Which means that if a if a Chinese company is investing in India, the Chinese government is likely to back that company both diplomatically and economically, and put pressure on the Indian government to accept any terms with the Chinese government which the Chinese government has forced upon that company. Secondly, we think that there is a mismatch of competition here, right? We think there's developing countries are always forced to compete amongst themselves to get scarce investors. On the direct comparative, corporations obviously have many developing countries in which they can invest in, which means they can always threaten to leave that country, and which would also be like very politically unpopular for that country, which means there is a comparatively larger amount of incentive for investors to renege on deals. Therefore, the question in this debate then becomes to which medium are investors less powerful, and are the poorer, weaker countries more likely to get their say, right? The counterprop that we run from opposition is that we think that you should be allowed to sue a company in the country in which they're operating in. This would mean that if a Chinese company invests in India and probably causes environmental damage or reneges on its tax agreements, the Indian government should be allowed to sue in Indian courts. Opening government says that they do not have jurisdiction. Firstly, I do not think that is true to begin with. Right? We think lots of multinational companies have been sued in the countries in which they've operated in. We think that is just unlikely. But even it is so, if government has the fiat to create a whole new body of international arbitration, we think we have fiat to create jurisdiction of courts, as long as we prove that the jurisdiction is coherent with general principles of justice. We think we can claim reasonable fiat on that. But some context before, just give me a second. But some context before I move on to my positive argumentation. We think free trade agreements are among countries which have relatively high levels of development. Right? They only get into these arguments if they have confidence in their economic and judicial institutions, and they know that they aren't going to get completely bullied by the other country. Notice that the power imbalance I talked about still exists, but this doesn't mean that we're talking about countries which have extremely terrible judicial systems, like say underdeveloped countries in Africa, etc. Which means that the courts in these countries are probably are likely to reasonably adhere to the basic principles of justice, and are likely to be reasonably free from biases as much as can be expected. Right? We think then the comparative in this debate is whether which mechanism is better towards resolving disputes, whether it is the international forum or whether it is the court of the country of origin. Framing here, we think that the people who are most affected by bad decisions of these companies are people who live in the countries that they invest in. Right? This would look like people losing out on jobs because the company didn't invest the amount they promised. This looks like tribal people being evicted from their land because the company has decided to open new mines where it doesn't have a permission. And this looks like people losing fishing folk losing their livelihood because the company has polluted the river. Which means that the most vulnerable actors in this debate are people who have been harmed by the presence of a multinational company, which means that the major question on which this debate should be adjudicated is on which side of the world they get better representation and which forum is better at providing them representation. Two reasons why local courts are better at providing representation to these people. Firstly, we think that the judges and lawyers in these courts are often going to be from areas where that damage has taken place. Right? We think on the comparative, in an international forum, the judges would probably be from a different country, and even if they're from the same country, the lawyers would be from like different regions, or would probably be from the elite metropolitan regions of that country, which means that they would literally have no understanding of what people within that region value and why it is that they value that thing. For example, it is very difficult for a person living in India's cities to know why a person living in the villages wouldn't want development, even if that gives him large amounts of money, because that land is sacred to that person. We think these sorts of trade-offs can only be made by courts within that local region. Secondly, we think that courts are much more accessible to local interest groups. Right? We think on our side of the world, people who are uniquely affected would be able to do things like file appeals in the courts, file public interest litigations related to the process. We think on the comparative, they have to rely on the representation of the national government in order to best represent their interests. We think it is unlikely that this representation would be perfect, because there are likely to be minorities who are affected. Right? Which means that the government wouldn't be we think on a comparative, we think these people would be better able to represent their interests if they have to approach the local court versus if they have to rely on the government in order to approach the international forum for them. The second argument I'd like to make is that international forum is likely to be skewed towards corporates to begin with. Two reasons why this is so. Firstly, we think that judges and lawyers in general would likely to be from rich developed countries. They're likely to be white, they're likely to be privileged, which means they would once again have no understanding of the lived experiences of these people. But even beyond that, secondly, we think that the people within international forums are often people who have gotten rich through the process of capitalism and through the process of globalization, which means that they are inherent believers in globalization, which means that whenever they see a dispute, what they think is that why are they complaining because they're getting money, they should be fine with it, right? They believe that like most judges in these international forums are likely to believe that globalization is a force for the good, which means that these people are likely to be underrepresented in government's world as well, right? Because we provide most representation to the most vulnerable, and because the metrics on our side don't become only capitalistic, we represent the most vulnerable stakeholders in this debate the best. Vote opening opposition.
All right, thank you very much for that, DPM.
Hi, am I audible?
Yep.
Yeah, Shwet, check WhatsApp before you start, please.
Just a second. I'll set up my timer as well. Three, two, one. I wish the two engineers in opening opposition would have heard the only lawyer in opening government, and he goes ahead and gives out the mechanism of how this is much better and is an addition to all the existing solutions that opening opposition talks about. Because the only mechanism that opening opposition has given is that we are fine with people going ahead and suing in local court. Notice that we don't go ahead and take that away because this house supports and not this house will ban X motion. But at a point of time, even if you go ahead and consider how the justice that they seek out on each and every stakeholder they have talked about never really happens. Notice the scenario. And I'm also going to go ahead and remind you that we never went ahead and made the prime focus that, hey, listen, states are always the sucks. But notice that to go ahead and get justice against the states when they go ahead and falter is far much more difficult, because they are the sovereigns who have monopoly over the violence and who are the only ones who can go ahead and ensures that the things against them can happen only if they consent to it. That is to say that it is much more difficult for an investor to go ahead and get justice against a state as opposed to vice versa. Because if states want to go ahead, there probably exists some form of result, because in their jurisdiction they can probably put sanctions on that company and all that host of results. But I'm going to go ahead and tell you why even state is better off in our world as opposed to theirs. What are the problems that exist? Let's begin with their mechanism. Going ahead and approaching local courts. Notice here exists two distinctions that you have to keep in mind. Either you go ahead and approach your local court because there was a zombie company from China which promised and paid you less as opposed to them. What do these corporations do? Even if you win the local case, notice that these things can never be implemented, or the decree that arbit court in their world goes ahead and gives can never be implemented in China. That is to say, China, because of it has an iron curtain, is never going to go ahead and accept it. But number two, it says that it's our sovereign right. We are not going to go ahead and do that. The very incentives that they talk about stops the decree being admitted. Number two, you approach China, which beats the whole point of their case, because now these Chinese courts don't go ahead and recognize you. And once Chinese court says that you don't have a jurisdiction, you don't go ahead and have any redressal at any form in any part of international world. That is to say, they don't get redressal. At that particular point of time, let's go ahead and talk about in terms of the only mechanism that they want to go ahead and give. Notice why arbitration is unique, and notice why this is an extension to the contract. The reason why they can't go ahead and claim the fiat that they can establish new form of courts is because we aren't claiming the fiat of establishing new form of jurisprudence. That is to say, ISDS, the International Investor State Dispute Settlement, already exists in the status quo. It's already recognized. That's why a British company that exists in forms of can go ahead and sue these zombie companies in China, and the Shanghai court has to go ahead and pass a decree for its implementation. This is the largest reason why a lot of corporations can go ahead and that the plagiarism that exists in China can be stopped, because otherwise they can't go ahead and sue in their local courts. That's why they prefer this already existing. What we are going ahead and this form of accountability to free trade agreements who don't have that accountability, that's the mechanism. No matter what anyone comes and says, that has to engage with this if they reasonably want to be true and fair in this debate. At that particular point of time, what is the problem that they had? Notice they go ahead and say that often judges are white, and that's why you are unlikely to go ahead and understand what it is. Notice the beauty of arbitration is that you choose your judges. That is to say, me, investor, chooses one arbitrator, state chooses another arbitrator, and those two arbitrators mutually decide the third arbitrator. This is the fairest form that can exist in comparison to all their courts, where mostly states will say, oh, your court decided it, which means it's not fair. This is the epitomization of fairness that exists. Then there exists the only case in terms of, hey, listen to the local people who probably don't want to go ahead and give away land. Look, that is regrettable and is unlikely to change on either world. But even at a point of time, it is inexclusive. We think our world is much more better because now these people have a legitimate redressal. That is to say, for the damages like Sterling Corporation, which went ahead and did against India, these people can go ahead and now in their arbitration, because notice that they have to sue in either world. Either they go to China in their world in order to get an effective remedy, or at best the local government. Once you approach these courts, once you approach arbitration, you have a chance of going ahead and getting those damages. And because of the diverse composition, because arbitrations are as diverse as it gets, and there exist centers all around the world. Singapore Institute of Arbitration Center, Mumbai Institute of Arbitration Center. That is to say, they can take place at any point of time. But the beauty of this is that local courts, that is to say common law and international jurisdiction, have limits to the pecuniary damages and often don't go ahead and realizes the damages in terms of like the US courts do plaintiff. These arbitration courts don't have that limit. That is to say, you are more likely to go ahead and get the appropriate remedy and appropriate damages in your world. The beauty of this is that it's the most fastest way. And this is the comparative, where litigation takes like years and decades in their world. These often have a deadline. Why? Because these are private institution arbitration centers who have to go ahead and quickly form the case, because arbitrators only get the money once they dispose of their case and then move to a next case, because one arbitrator can't judge two cases simultaneously. He has to finish this case and then move on to the next one. At that particular point of time, you're more likely to go ahead and get any form of redress. Last chance to see you.
Right. I don't understand it. Me? I don't understand this argument on why you're more likely to. What's going on?
I'm unable to hear you. I'm stopping my timer. I'm unable to hear you. I'm sorry. I haven't heard you in the last 20 seconds. Is it okay, Judge, if I stop my timer? And can CEO ask me a POI and then I'll begin my timer?
Yeah, I stopped
CEO,
6 minutes, 14 seconds.
Right.
So CEO, proceed with your POI. I'll begin the timer then.
Right.
Can you begin it after he asks? Because like he was trying to ask for the last 20 seconds. Yeah, thank you.
Okay, I'll ask,
Yeah, go for it.
I don't understand the exclusivity of this extension. Presumably, if the discussion is local courts, then in the FTA, there will be an agreement on local courts. Why do you uniquely get agreement for international arbitrators?
Simply because the local courts, if there exists, it can't be implemented. That is to say, if you go ahead and tell state that you need to go ahead and follow because you have defaulted, state goes ahead and says that we will do it. And there is an appellate process that takes decades and decades and decades. Corporations, often because the corporations have shell corporations, you're unlikely to institute it against them. An arbitration deal corporation, and you go ahead and exist in terms of say USA, you can implement it in USA, you get your redressal against that corporation. It doesn't happen in your world. Notice at the end of this debate, and the only thing that matters, both can make mistakes. That is to say, both investor and state can be at fault. At that particular point of time, this is about the fairest way to redressal. This is about the fairest way to get accountability and justice. Notice the flip on their world at a point of time when there are zombie Chinese companies which go ahead and don't do what they have rejected and actually leave states at default. States can't go ahead and do much because there exists larger interest against observing and preserving with Chinese nations. Now courts now nations can go ahead and go after these zombie corporations and get the damages for the damages that they have done. That's the truest essence of justice. Even if you buy nothing in this debate, you need to buy that there needs to exist a problem in the status quo, and they can't solve it. Only Gov can.
All right, thank you very much for that. DLO.
Hello, am I audible?
Yep, you are.
Just give me 10 seconds. Okay. Starting my speech in 3, 2, 1. The biggest reason why opening government loses this debate is because to every single logical response that my partner pointed out to you, they have a mechanistic defense, right? That this is just not possible. That's why we'll do this. I'm going to beat the logic of each and every mechanism that DPM provided in their speech. But before that, let's just deal with the end impact of opening government. It is that we solve cases faster because arbitration has a deadline. If we prove to you that these cases are extremely important and complex, and there are people whose lives are at stake on the comparative, we think in fact a quickening and forcing the process to end at a particular end date probably is not the best decision for government bench to begin with, right? In the vast majority of these cases, these are extremely complex, where it's not like you're outrightly going out and killing people, but there are subtle ways in which you are violating people's autonomies and violating people's freedoms. This looks like you going ahead and taking away sacred land of people with the promise that you'll give them back employment, but you don't do that just because, I don't know, Chinese zombie companies like Shweb pointed out, right? So for all of these reasons, we think that just the magnitude of impact of these kinds of cases on people's lives means that we are fine with trading off time just insofar as we can get a more representative redressal mechanism, right? The only impact that opening government has in this debate is a quick redressal mechanism. I'm going to frame that out on the comparative. But let's deal with every single mechanism that opening government talks about, right? Because they largely frame the investors as the victim in this case. We think in free trade agreements, the investors tend to benefit because they get cheap labor, they get cheap land, and they get to expand their businesses. And the governments also largely benefit because they get to project their short-term economic agendas in those political cycles. They get to say, we got you $1 billion investments, we increase jobs, and all of those advertising things exist. That's why in most of these instances, both of these parties are almost always going to benefit. The people who suffer are people on ground who are always who are just always brushed aside because of these short-term economic goals and have literally no say in that entire process. And the only entity that can ever represent them is the judicial process, which is bounded by a constitutional mandate which protects rights, and not the short-termist economic agendas that thrive both the corporations and both the local governments. Right? We think this is the fundamental premise that opening opposition tackles in this debate, which is why every single other impact in this debate is just a mechanistic extension. But we'll just show to you why our alternative is the most representative redressal mechanism. The second thing that OG says is that it's too difficult and it's too time-consuming. But notice the power imbalance here, right? Investors always have support from their home country. So if a US corporation is in India, US can always exert diplomatic pressure on the Indian government, right? That's why all of those power imbalances exist. The company itself is too powerful. They can always threaten to leave you because there are multiple other alternatives exist for them. They can go to for cheap labor. And often you are the one who doesn't have choice here, right? Like the company has made the deal with you saying that we are going to generate 1 million employment for 1 million people. And once the deal exists, you are the one who's always held on the gunpoint, right? Because if at any point of time the company threatens to leave, you are now answerable to the people that, how will you create 1 million jobs that company was going to create, right? That's why at all points in time, this power imbalance exists. And in that context, the people on ground suffer, right? The second thing that opening government said is that this is an arbitration body and the set of laws that everyone agrees to. But we don't get this mechanism to begin with, right? If the free trade agreement doesn't include ISDS and includes local courts, etc., we think companies, investors, etc., can still consent to these same kinds of mechanisms. And literally, jurisdiction is something that these local courts should have because people on ground are being harmed. And we don't get this ridiculous response that Chinese courts won't agree to you. We don't care about Chinese courts. If the Indian courts, which is representative of the people's will, decides that you can no longer be a part of this free trade agreement because you violated and because you've caused a dispute which threatens people's fundamental rights, you just have to leave that company. You're just forced to leave that country, and you're not forced to bully governments into accepting your deal at all points in time, right? We think this bullying specifically happens because both the parties who are going to be represented in the arbitration are parties who are governed by these kinds of short-term agendas, right? We think this is particularly important even to the mechanism that DPM pointed out, that you get to choose your arbitration, which is why arbitration is beautiful. Exactly. The government gets to choose those arbitration, and the government is already someone who's going to be bullied by those corporations or who already has lesser lesser kinds of say to begin with, right? The only entity which cares about rights, the only entity which is not plagued by these short-term economic incentives and won't trade off democratic rights or won't trade off people's autonomies just for short-term economic goals is the local courts, because they're bound by this kind of a constitutional mandate. The last thing that I want to note here is that our mechanism is just infinitely better in terms of representation, right? Why is this the case? When you have local jurisdiction, every single person is now allowed to file litigations, right? That mechanism doesn't exist in international arbitration. Like, it's ridiculous for them to even posit that people can go and like go to the Singapore Institute of Arbitration and file complaints, right? At best, what happens is that the government gets to choose an arbitrator, the company gets to choose an arbitrator, and they resolve that dispute over there. People don't get any say in the vast majority of the cases. But even if they get any kind of say in this entire process, it's always likely to be majoritarian and not localized to the kinds of people that we are talking about, right? In the vast majority of the cases, what we're talking about is sacred lands being taken away. It's about rivers being polluted by these companies, which is an extremely local issue, which is an extremely tribal or a minority issue, which probably at best has some representation on a state level. At the country's government level, you have absolutely no say. The country's government is likely to be majoritarian. The country's government is likely to be like driven by those same kinds of economic agendas and is very unlikely to represent you. In that context, we get the most representative redressal mechanism. Before moving on, I'll take closing.
Yeah, so if you're so afraid that all companies will make all of these abuses, why don't you just put in like regulations in the FTA or just like regulate them?
Sure. We are obviously afraid, but the point is, when you're making this kind of a free trade agreement, you're often at the mercy of these investors because you need money desperately, which means either the regulations don't come about, but even if those regulations are put inside the free trade agreements, it is still possible that companies violate them. It is still possible that disputes still happen regardless of those regulations being a part of the FTA, right? This debate exists when those disputes happen despite some level of regulatory mechanisms already existing in the FTA. The last ridiculous thing that opening government pointed out is that this house supports motion, so we are just adding on to the number of mechanisms that we have. This is just ridiculous. They have to defend a world where they only support international arbitration and don't support local courts, right? Because like literally, if the contract of the free trade agreement is going to be, if at all there is going to be a dispute, we'll go to Singapore International Institution of Arbitration. You then can't, the company will then never consent to being a part of this local jurisdiction. Therefore, we always need to exclude this kind of an international arbitration process, which is more likely to be colored. But the same mechanisms that opening government pointed out are reasons why these mechanisms are going to be plagued. Because if you have to go to the Singapore International Court of Arbitration, you are just disjoined from the people who are being harmed. It's very difficult for you to ever understand those problems. But B, it's just most of these arbitration centers, probably like the mentioned examples, exist in those capitalistic senses anyways, right? Like most companies and most countries in general are driven by capitalism and will always ask you, what's your problem? You're getting 1 billion jobs, just settle with like your rivers being polluted or just settle with your sacred land being taken away, right? They'll never care about the fundamental issues that harm these countries. We are not saying that we don't get those investments. It's just that we get a more representative system. That is to say, if our courts determine that the laws that we are making in terms of rights are fair to be traded off with the economic development, we are still fine with that. We are going to make that trade-off at a court level anyway. We are just saying that the only body that can truly represent the people without being plagued by short-term economic incentives is local courts, which is why we ask you to support opening opposition in this debate. Very proud to oppose.
All right, thank you very much for that. And to open the closing half, member of Gov.
Hi, mic test. Coming from closing government, I'll be doing 4 things. One, I'll actually be discussing what does ISDS look like, what are the provisions under it, and in what instances can these companies even sue? Because I think there was a general confusion in the opening debate where countries and companies can literally just sue for anything. This is not what ISDS is. 2, I'll be talking to you then about why these protections and accountability is important. 3rd, I'll be telling you then why this is good for economic development. And lastly, I'll be telling you why this is good for international relations. But before I move on to those discussions, just a few things I want to get out of the way to deal with opening opposition. 1, I think that there was a clear contradiction coming from side opening opposition. On one hand, they say free trade agreements occur between countries with high level of development, therefore courts are unlikely to be biased. Anyway, you can trust local courts to be able to rule fairly. But at the same time, they say free trade agreements happen between countries with levels of power where one country is stronger, therefore one developing country is bullied into entering it. What is it really? Because if there is a developing country that is in the picture, then I would imagine that they also have to concede that to some extent, democratic institutions in these places are weaker. Therefore, the courts are likely to also be weaker. So we think that that needed to be clear coming from them. They can't have their cake and eat it too. But secondly, I think if they say that free trade is so imbalanced where developing countries are bullied into accepting these deals, I would posit in fact that ISDS is something that is good. If they say that people are these countries are so irrational because they need money and because they need employment, I think that the inclusion of ISDS, where you say that there's a potentiality that you will be sued, means that there's an actual trade-off and that they will have to consider that they otherwise would not have considered before. We think that this is what actually introduces rationality into the negotiations if what OO says is true, that people always enter into these negotiations with an irrational mindset. We think that this is where they're more likely to really question what they want to do, and we think, in fact, it is better for their decision making. The rest of my responses will be integrated in my discussions. So first, what does it mean when you allow due process to happen? We think fundamentally, if corporations are abusive, then they can be held accountable to what was signed in the agreement. Because that is to say, even in the worst case presented by OP, that they sue with no probable cause, it's fine, right? Because courts will be able to identify that no clause in the agreement was violated to begin with. So even if it's, again, in the worst case of OO, that the judge doesn't really know about the Indian people and the Indian villages, and they will have no basis to rule. We don't think this is true. We think that they can be like impartial to what was agreed upon in the free trade agreement. What are the clauses in which companies can decide to use ISDS and sue these countries? We think that this is something that is possible. But moreover, we think that if there is no inclusion in free trade agreement, it is something that is fundamentally worse. Because if OO says that investors are as selfish as they claim, it means that they are more likely to act in a way that is more harmful and more antagonistic towards these host countries because they feel as though they are deprived of justice. So if you want to look at where you're able to actually achieve due process better, even when these places are abusive, we think it's better where ISDS exists. So what does ISDS look like? And I want to give you the example of NAFTA where they actually have ISDS. One, the first clause is fairness and due process. But we think that this is something that is not possible if you allow things to be arbitrated within the host country. Why? One, I already told you, developing countries usually have weaker democratic institutions, which means that governments are more likely to control courts. But two, even if they don't, we think that judges in courts are more biased towards their own people, that they are just unlikely to care about that white company rather than the people who surround them within that court to begin with, right? But secondly, we think then that given the other clauses within the ISDS, fairness and due process is extremely important. Why? Because the other clauses include things like compensation for foreign government seizure of property, things like non-discrimination, where host states need to protect these investors in the same way that they protect their domestic investors, or where they cannot discriminate between investors based on their size or based on what nation they came from to begin with, right? We think that these are things that are fundamentally important because these are actual harms to these corporations to begin with. The fact that governments can just simply take away their property and these individuals can't do anything about it, or the fact that they can simply nationalize your foreign direct investment and expropriate it when it's something that is fundamentally harmful as well. What do we then want to achieve coming from our side of the house? We want to first promote investment because we think that obviously it acts as an incentive where these countries no longer have to fear that my intellectual property rights will be violated by this host country where they're going to steal our products and sell it themselves, right? Or develop it themselves, right? We think that this ensured legal protection and the ability to ensure that they will be treated fairly also means that they are more likely to invest, therefore giving people jobs and whatnot as well, right? Because we think that it is fair for opposition to always assume that these investors are bad. We think fundamentally it is actually when you give them more protections that they are more likely to be benevolent in how they develop your country as well, because they also want a long-term relationship with you and get that return on investment to begin with, right? But secondly, we think that it is only with the inclusion of ISDS where you're able to depoliticize disputes between investors in countries where these investors came from and these host countries to begin with. We think you don't want a world in which countries where these investors came from intervene and get angry that the country in which they signed the free trade agreement with is harming the investors that came from their country. If it's true what OO says, that China is a country that backs all of their investors and bullies you if you abuse them, we think that this is worse, right? At least if you have ISDS, you can look towards an impartial court and companies are able to say that, yes, we have it handled, rather than having China intervene and having more countries in dispute, right? FTAs are supposed to entwine in economies and bring diplomatic relations, but what you do instead when you don't have protection for these corporations and they get angry, that's where you create more antagonism between these parties to begin with. Thanks.
Okay, thank you very much for that, Member Bob. Bench, GovWhip.
Hi, am I audible?
Mhm.
Okay, thank you. Free trade agreements hold massive benefits for countries involved, but only when they are fair. Unfortunately, the distrust and paranoia around free trade agreements is or the idea that this is simply Western imperialism or simply a means for developing countries to steal jobs from the middle class in the developed world. All of this distrust and paranoia is cemented when you have exactly what closing government and closing opposition and opening opposition talks about, where the government can suddenly just change its minds about priorities in terms of the economy after years of negotiating a free trade agreement, or the idea that a country can just steal your intellectual property and you can't do anything about it. On their side of the house, this results in less free trade agreements entered into, more protectionism that leads to greater poverty on their side of the house. We see this in countries like Brazil, Philippines, not being willing to have more foreign investments because they fear that they have no legal recourse because they have very little power against these bigger countries and bigger corporations. Let's be clear, right? On our side of the house, what we are saying is that the point of these courts is to limit conflicts of interest and potential ideas of abuse. This is done through, for example, the arbitration of having diverse legal and economic experts, just looking at the deal, like on paper, were there any violations? We think this is far fairer on our side of the house. 3 questions, right? 1, does this ISDS actually work? Will it be binding? Because that was the ridiculous attack coming from closing government. First, if they don't follow the whatever ruling came out, I think it's far worse for the country that is unwilling to abide by something they voluntarily entered into. You will basically be like China, not being willing to follow the PCA ruling on the UNCLOS on the rule of the sea, right? It makes you such that you are a red flag for future investors because now they see you're not even willing to abide by any legal doctrine at all. On your side of the house, you close yourself off from future investors if you are just seen as a country not willing to abide by anything, even something they agreed to. But second, I think you can just sanction them if they are unwilling to follow the law anyway. But lastly, if something that is so public is not binding, what more something less transparent on their side of the house, which are local courts, right? Why would these big, evil, powerful companies follow the ruling of local courts on their side of the house, right? I think on their side, it's far, far less likely that you have something binding. So that's just getting that idea out of the way. Second question, is this fair, right? The first idea coming from up is that local courts are far, far fairer. Why? No analysis at all. Second, if this is true, that all courts are fair, right? The assumption is, well, courts are fair, they follow the law, there are judges. Why won't our courts be fair, right? I think that is quite symmetric. But what we told you, why their courts are far less fair, is the idea that 1, it's less transparent. Second, it's the idea that the government has power to threaten these companies, the idea that you have to settle or we'll find a way to shut you down, the ideas of the power asymmetry of governments on our side of the house. This is what member of op brought to you. No response coming from member of op, right? And it's too late by whip. What we told you was that there is an asymmetric power in government on being able to, for example, control courts. Yes, courts can be captured. For example, in the Philippines, where it became legitimate to shut down the media, there was the courts being able to find unrelated loopholes in order to take down that business for national interest, quote unquote, right? Or even just the idea, secondly, on their side of the house, where you have corporate capture also, right? The idea where despite, for example, violations by a big country, the state might be too afraid to do anything because otherwise they will just pull out. But on our side of the house, when you can bring this to a legitimate actor where it isn't something that you do against them necessarily, we think it's less likely that these countries are unable to seek justice, right? Second, they say that, well, companies will be unfair and just pull out. One will tell you this is just far less likely. Why? 1, it's the idea that it's incredibly expensive to outsource and build an entire company in a foreign land, right? You're not just going to waste money and then pull out. But second, in the instance that you're so afraid of any violations from these companies, I think the state has far more mechanisms to shield against that. Like I POI'd, you could put this into the FTA, you can't do certain things that harm the environment, etc. But second, I think you can also still have state regulations anyway, right? You can tax them, you can make them follow your laws, or else if they don't follow your laws, like obviously they can't operate legally in your state and you can legally shut them down anyway. The state has so much power, guys. But lastly, arbitration would still exist, right? On our side of the house, these states could still bring this to the same courts that we are proposing. Lastly, I think that this argument about companies like not holding up their end of the bargain is an argument against any foreign investment or even investment by big companies in general, because obviously no company can assure that they will like solve unemployment and poverty. That's just ridiculous. On our side of the house, what we stand for is just having greater like ability for weaker actors involved to have and be able to seek justice, which just doesn't happen on their side of the house. Before I move on, I'll take a POI.
Even if democratic institutions are weak, tell me why governments are less likely to be bullied on an international forum as compared to being bullied in the courts of their own country.
Okay, so like in general, the idea of like bullying, etc., is far less likely when you have a diverse set of individuals representing things like the economic interest, legal interest, etc. Second, I think that the idea of bullying is far more likely on your side of the house. Why? So, for example, in a world where there's no arbitration, states take it upon themselves to settle this unfairness that this developing country is still protecting their own industries, right? Instead, what I will do is sanction them, right? Instead, in order to get justice, I will threaten them with cutting off economic ties or other embargoes. I think on their side of the house, you risk escalating these tensions to become far more political and far more macroeconomic rather than just having the court settle it between the company and the state. So what do we prove on our side of the house, right? The second idea is that we are also able to prove this is better for the economy and international trade, where you protect diplomatic relationships. The idea here is that with these courts, you're better assured of stability and you are able to provide investor confidence. On their side of the house, Trump, for example, can do things like pull out of NAFTA, which hurts other countries as well, like Mexico and Canada, right? The businesses aren't sure should they close down, change logistics, which result in things like capital flight and these countries having to renegotiate the deal for themselves. On our side of the house, because any violations will be brought to court, now it's less likely for these states to just willy-nilly pull out of the deal whenever they change their minds, like CO said, right? So on our side of the house, with greater investor confidence, that's where you have greater inflow of capital for development, etc. Our side of the house provides legal recourse, provides deterrence, and normalizes the idea of following international law, which is incredibly important if we want more countries to enter into FTAs. Thank you.
All right, thank you very much for that. And to close this entire house, Upwip.
Sean went to the toilet. He'll be back shortly.
Okay.
Hi, can you hear me? Okay.
Hurry up, Lee.
3, 2. The first thing I want to do, panel, is just to take opening half out of this debate. Opening opposition's arguments are out because they are dependent on two things. One, they are dependent on an incredibly specific context that the investor is the one at fault. Note that this stood directly against the opening government's context that the state is always the one at fault. The actual answer, I think, is that both of them are at fault, and that's why it's investor-state dispute resolution, so both of them could be at fault, and both of them could be making claims against each other. So any case that depended on one or the other is out. Second, I think that case that you heard from OO is dependent on a very specific solution of local courts. Note that I don't think they have fiat to determine that this is the one solution that is the comparative in the debate, as much as one of a range of other solutions. But the reality is, if you think about it, if the country is so in such an inferior position, it is and so reliant on the corporation, it is unclear to me that the court is going to be uniquely fair. But it's secondly unclear to me that the court is a unique actor that should be able to make trade-offs on behalf of the people. And I think those are the assumptions behind OO's case that just mean that their case has to be less relevant in this debate compared to what we told you in closing. So let's deal with OG therefore. I think the most charitable thing I can say about OG is that they hang their hat on the idea that they will get faster change on that side of the house, that faster change is a good thing insofar as you want investments. First, it is entirely unclear why their problems are necessarily inherent and why we can't create faster mechanisms of state dispute resolution. In fact, I think what we tell you in closing is that state against state has an inherent incentive to get to this change a lot faster because states have a multitude of issues that are involved in their international relations, as Enzi told you, and you just don't want to lag. But also because there's a social pressure to create solutions that governments are democratically answerable to, that means that there are existing incentives to make the situation faster than it is on that side of the house. But I also think that example of arbitration is just incredibly assertive on that side. If you're dealing with Indian arbitration centers have a lot of cases that are inherently quite cheap, quite complex, it is highly unlikely that they're able to get this arbitration as efficiently as they claim they would. Note also that I think these individual corporations have less freedom to trade off and negotiate as compared to states because they're beholden to like stockholders, for example. They're beholden to their board of directors, which means that it's likelihood that you get fast negotiation in terms of a corporation versus state dispute is limited, which seems to me to take out the core benefit of the opening government that you get faster negotiation, and that's a good thing. Let's deal with the meat of the debate therefore, and I think closing government and the closing half clash. The first thing I want to note is that the premise behind the entire case that you heard down the government bench is that they get effective enforcement, and the only reason that they give you for this is clearly saying that you must listen because you don't want to look bad. The reality is at the point that you are in a dispute, it is likely that someone was willing to look bad anyway because they concluded that the benefit that they could get from reneging on the agreement was more likely to be beneficial. Therefore, it's entirely unclear to me why the idea of image and reputation is going to be a significant motivator on that side of the house. But second, the reality is that if you want to talk about things like sanctions, that inherently requires the state. Unless the burden that closing government is willing to take on is that this independent arbitrator can force the state into sanctioning another state based on the decision that was made on behalf of a particular corporation. And that's where I think the case that we gave you from closing opposition becomes incredibly relevant here. Because the reality is that the biggest argument on government bench that is the only way any gov team can go through is investment is an a priori good and we should always support investment. That's why all the conclusions tended in we get more investment and that's a good thing. The question I think is more relevant is how should we make decisions on how we want to deal with this benefit of investment and how far should we weigh investment as a benefit in this debate? Who should do this weighing? Because the reality is that investment is just not an inherently good thing. If it was, we would have like every country would have FTAs with each other already. There wouldn't be so much negotiation over the way in which FTAs because you would just want more investment because more investment equals more money equals good on that side of the house. The reality is that that's not the case because you recognize that investment and this potential economic benefit weighs against a whole lot of other things that people have the legitimate right to decide in this debate. And that's why our governments are not purely economic technocrats, right? The point is that this motion applies where a decision must be made on whether the confrontation that is necessary in order to get this investment on that side is worth the economic benefit of investment. The argument that we gave you at NC was therefore that to the degree that FTAs are signed on behalf of states and states sign these FTAs on behalf of their people, that the state and the new government is therefore the unique actor that is primarily placed to make decisions on how this FTA should work. That's why we supported the status quo alternative of states choosing to take this up within this international international arbitrations with other states in through potentially bodies like WTO, but essentially that the dispute should be resolved in state versus state instead of state versus investor. That was what was critically important. I heard two responses from the government. The first thing she says is that there is mistrust because a new government can change policies. The comparative on that side is mistrust because the old government signed trade policies that locks in every government in the future based on the very strict terms of that particular agreement. Because investors are able to use that particular agreement to be the way in which they force their benefits to come true. The problem with that is that you get mistrust against and anger against these old agreements in the first place, right? Things like anger against TPP, anger against NAFTA. And that means that you have more feeling of not being in control because your current vote as a voter means literally nothing in so far as you are locked in by the previous agreement. That creates more anger against the concept of trade and more economic nationalism, less willingness to be open to trade, which doesn't achieve the end benefit on that side of the house. The comparative is that when we allow people to use the democratic process, we are better able to achieve the benefit of people caring and being open to trade. Then they say the problem is the asymmetric power of the government. That's kind of the point. Obviously, we think that the government should have a significant degree of power over their corporations. The closing government's best case scenario of investors winning is exactly what Ernst said was bad. Just think about it. In any other situation where you say you would rather the corporation have more power than the government that represents democratically elected people, we would say that's really, really fucked up. And the reason for that is one, that the interest of the corporation tends to be against the majority interest of the people because the corporation wants profit and people want many other things other than profit that is unlikely to trickle down to them in the first place. Two, she told you that this creates a precedent to sideline the state where corporations are able to use to just avoid dealing with democratically elected representatives because they go straight for the arbitration of opening government. But three, she told you that democratic institutions are critically important. The ability for people to feel like they have control over the economy is incredibly important. If this means that we have to defend the world in which Trump makes decisions on behalf of the people, we're willing to do that because he's a democratically elected president, and the premise of democracy is that we have to listen to this. The final thing they say is that they want to depoliticize. The point that we argued was that this is inherently political because their assumption is that people can distinguish between a Western company and a Western country suing you, which we suggested was incredibly unlikely because most discussion about politics just doesn't reach that degree of nuance. The question therefore was, do we think it's legitimate for all of the efforts to create this kind of international linkages to be ruined by particular corporations deciding that it will be in their benefit to sabotage this in order for their particular economic benefit? We thought that at the end of the day, that went against the fundamental reason for the construction of the state and the concept that the state speaks on behalf of the people and therefore that the people should be the ultimate arbiters of their own destiny and whether they want investment or not. That is what we proposed.
Right. Thank you very much for that, debaters. Please exit this room as the results will be announced in the main chamber. Thank you. So everybody who is other than the three panels that have joined me,